Welcome, everybody. I'm very pleased to introduce the next episode of our Preserving Perspective series, oral history project of international arbitration. And this one is a particular homecoming for me. I've known both Arthur Rovine and Charles Brouwer since I began as a legal assistant at the Iran Claims Tribunal in September of 1984. And you're going to hear a lot more about the Iran Claims Tribunal. Let me very briefly introduce, first I'll talk very briefly about Charlie Brouwer. Neither of these people needs introduction, but nonetheless, I won't spare you. Charlie is a judge ad hoc at the ICJ, sitting in 3 active contentions proceedings now. Since 1983, he has served continuously as a judge at the Iran Claims Tribunal. Before that, he was at the Department of State, including acting as acting legal advisor, and for many years at White & Case. And he's a past president both of the American Society of International Law and a past chairman of this institute, the Institute of Transnational Arbitration. And in that capacity, he got me involved in ITA, for which I'm forever grateful. Art Rovine, the star of our show today, is today an international arbitrator and adjunct professor of law at Fordham. From 1981 to 1983, he was the first U.S. agent at the Iran Claims Tribunal in The Hague, where he helped establish the tribunal and argued cases on behalf of the U.S. government against the government of Iran. After leaving the tribunal from 1983 to 2005, he was a partner at Baker McKenzie, served as counsel in many international arbitrations. He retired from the firm in 2005 and has been teaching and sitting as arbitrator since then, and writing as well. So I give you Charlie and Arthur. Thank you.
Great. Thank you. Well, the first thing you need to know about Arthur is he comes from the cradle of liberty, if you accept that Philadelphia is the cradle of liberty and are not still claiming that it was in Boston after all. And that explains why, since he was 25 years old, he has been consistently and consecutively involved in international arbitration and other forms of international dispute resolution. So, with that additional introduction, why did you become a lawyer?
Well, it started, believe it or not, in World War II. I was 7 years old in 1944, and I had 2 first cousins who were killed in the war, one in the Battle of the Bulge and one died in a Japanese prison camp in the Philippines. It had an enormous effect on me, on my family. It was just awful. And at the same time, my father was very much interested in the war, and we would go over the maps where the troops are today and where they're likely to be tomorrow. And there were certain events that were a big deal. The crossing of the Rhine was a big deal. Hiroshima and Nagasaki, of course, I remember well. And notwithstanding the huge destruction, horror to the civilians in those 2 cities, it brought the war to the end. And I remember being very happy about that. But most important was the reaction after the war. Peace, United Nations, international organizations, international law. And I glommed onto those like crazy. And I kept with it. My interest in all of that just kept up all the way. In college, I took as many international courses as I could, and then law school, the same, especially a course from a young assistant professor named Steve Schwabel, who became a judge on the World Court and subsequently president of the court. And he offered a seminar in the protection of foreign investment, and that rang a bell. By that time, I knew there was something called international arbitration, but I couldn't take a course in it because Harvard didn't have a course in it. Now, of course, such courses are all over the country. In any event, yes,
That's why
that had an impact on me,
Okay.
and I stuck with it.
So you graduated from the Harvard Law School. By the way, I was a member of that same class. I was sitting in the back hoping I wouldn't be called upon, and people like Arthur were speaking up and volunteering. So he was really into it. So after graduating from Harvard Law School, what came next?
What came next was, believe this or not, I, along with a classmate named Tony D'Amato, who's now gone, went to Columbia to get a PhD.
Why would you get a P? Not an SJD?
And not an SJD, because the PhD program at Columbia was perfect for a guy like me. It was a combination of international law, international organization, and international politics. What could be better? Tony felt the same way. And so we went to Columbia and got PhDs.
Well, then I understand at age 25, while you were beginning this, these doctoral studies, suddenly you got involved in the Southwest Africa case brought by Ethiopia and Liberia, which is famous in international law history
Yeah.
at the International Court of Justice. How did that happen?
Well, I was at Columbia, and those cases had been brought. The chief agent for the claimant states, Ethiopia and Liberia, a man named Ernest Gross, he called Professor Lizitzin, whose international law course I was sitting in, asked for a recommendation. Professor Lizitzin recommended me. I saw Gross, he hired me, and I got involved in the case, and it was fascinating. It was over the mandated territory of Southwest Africa. Today, of course, it's Namibia. And I argued that the mandate obligation had been violated. The obligation was to promote to the utmost the material and moral well-being and social progress of the inhabitants of the territory. Well, classical 19th century colonial language. But my view was that apartheid, which South Africa had instituted when the Germans left, they had problems elsewhere, that couldn't possibly have met that obligation of the mandate to promote to the utmost. And there was a standard around the world that said exactly that. You don't separate peoples out on the basis of race. And I use that as what I called a standard. It was not yet clear that apartheid was a violation of international law. We're in the mid-60s now. But I argued it anyway. It was a bit of a stretch, but I argued a norm and standard. I remember the translator at the World Court coming to me and said, you know, we have a problem. The word for norm in French is norme, N-O-R-M-E. And the word for standard in French is norm, N-O-R-M-E. What am I going to do with this? I said, I'll tell you what you do. In the English text, use the word standard, but put it in quotation marks. And that's what he did. And to this day, you'll see norm and standard in quotation marks. It was very funny. In any event, the case had a tragic outcome. In a contentious case, as you all know, the World Court, each side gets an additional judge. So the 15 became 17, fine. However, the jurisdictional phase, and there's always a jurisdictional phase in a contentious case at the court, it was decided by a vote of 8-7. One vote. That was close, real close. And then the worst happened. 3 judges on Ethiopia and Liberia's side were out. 1 died, 1 had a serious heart attack, and one was disqualified because he had taken part in UN debates on the subject. That meant we were left with 14. An even number can be a disaster, and in this case, it was. The argument I made was picked up lock, stock, and barrel by Phil Jessup, who was the American judge on the court at that time. And he had 6 others with him, but that only made 7. There were 7 on the other side who argued essentially a standing argument that Ethiopia and Liberia had no interest in what was going on in Southwest Africa. That issue had been decided in the jurisdiction phase, but they just reversed it because they could. They now had the votes to do it. It was 7-7, and in that situation, the president of the court, Sir Percy Spender of Australia, gets what's called a casting vote. And of course, having already voted for South Africa, he voted for South Africa again. So it was 8-7 the other way.
That was the last time that actually a contentious case was decided by a casting vote until early 2019. I mean, every other president of the tribunal did backflips not to be in that position. It was incredible. Well, that was a great start to getting your PhD. What was your subject of your dissertation?
I wrote on the undersecretaries of the UN, something that had never been written about. And in 1970, I published a book called The First 50 Years, the Secretaries General in World Politics. And it went up through Utah, started with Sir Eric Drummond, a terrific Secretary General from England. Then came Avenel from France, who was more or less pro-Nazi. That was not so terrific. And then came Sean Lester when the League was essentially done.
Okay.
Dag Hammarskjöld, Trygve started for the UN, Dag Hammarskjöld, Utah, and that was the end point for me in that book.
So you got your book published and you got your another graduate degree, all generally in the same area. So where did you go from there?
From which point?
From with your your PhD. I keep thinking law degrees. I understand.
Oh, I went to teach at Cornell.
Right.
And there I was in the government department teaching international law to government students, and I also taught international law to law students, obviously people in the law school. So that's what I did at Cornell. Then came the notice there was an opening at the legal advisor's office. And I'll tell you, to me, that is the single greatest international law office in the world, second to none. It handles every single issue of international law, including arbitration, that you can think of. And I jumped at the chance. Mark Feldman, deputy legal advisor, called me in one day to his office. Arthur, we would like you to be the U.S. agent to the Iran U.S. Claims Tribunal, which have been set up by the Algiers Accords. And, well, what does the agent do? The Accords don't say much, but it does say that the agent represents the U.S. government. That was enough for me. Before I left his office, I knew the answer had to be yes. And I went home and told my family. We were going to The Hague for the next couple of years. It could only be 2 because my son was about to start college in 2, and I didn't want to be in debt. I didn't want him to be in debt. My daughter, 4 years later, same thing. So it had to be limited to 2 years. They asked me to stay for a third, but I just couldn't do it for that reason. In any event, my daughter cried bitter tears. She had to leave her friends in Washington and didn't have any friends in The Hague. And I tried to persuade her she would keep her friends. She would make new friends. She would have a chance to travel around Europe, and she cried bitterly. It was a bit easier for my son, but we went.
Let's back up a moment, because at the time you were asked this, you were already the assistant legal advisor in charge of treaty
Treaties.
affairs.
Right.
And if we go to the time of the adoption of the Algiers Accords, which was, and the period before that, in late 1980 and 1981, you were involved in a series of cases and issues in that capacity, involving the tribunal to some extent, but also such things as the President Carter's termination of the Mutual Defense Treaty
Yes.
with the Republic of China.
That was a
otherwise known as
biggie,
Taiwan.
and Charlie was involved in that. Nixon and Kissinger, as you know, had decided to open up diplomatic relations with the People's Republic of China.
That came later.
No.
No, this is the Jimmy Carter.
No, this was much earlier.
No,
Jimmy Carter, the negotiations took a while, and they were successful, but there was one catch.
yeah.
China insisted that the United States terminate the Mutual Defense Treaty with Taiwan. I was head of the treaties office, so the question came to me, how do you terminate a treaty? I was surprised I got the question, because to me it was like a cabinet officer. When you want to appoint him or her, you go to the Senate for advice and consent. But if you want to fire that cabinet officer, you just fire him or her. So, but they wanted a memo. So I did a memo on every treaty termination in the history of America. And it's been done every which way you can think of. And at the end of it, I concluded it would be a good idea to consult with the Senate, but there's no obligation for them to give advice and consent to a treaty termination. It had a 1-year notice provision in it for the president to give notice of termination. That helped. Everybody was happy to receive that advice except Barry Goldwater. The treaty was terminated, and he sued. He sued the president, and he sued Cyrus Vance, who was Secretary of State at the time. And he brought a lawsuit in the district court in Washington, D.C. before Judge Oliver Gash, another big fan of Taiwan, and he won. And having won the case, he wrote or signed a letter to President Carter saying, Mr. President, you have been the victim of some very poor legal advice, and I strongly urge you to fire the guy immediately in the State Department who's responsible for this. Well, of course, the letter came back to me. I had to answer it. And the obvious answer was, it's up on appeal, which it was. And it went to the D.C. Circuit Court of Appeals, full en banc. 9 judges, 1 died or was not there, became 8. There was that even number again. And I thought, oh, God, an even number. Same arguments were made, threw in the political question doctrine, which turned out to be crucial, and 8-0 in our favor. Now Senator Goldwater had to appeal, and he did, to the Supreme Court, and they took the case. And some time went by, but a phone rings on my desk. Arthur, the court opinion is down. Send somebody to pick it up, which I did. And 7-0 to 2 in our favor. 2 justices wanted further argument. Other than that, it was 7-0, and it was Justice Rehnquist, the most conservative member of the court at that time, and a strong proponent of executive power, who threw Barry Goldwater, of all people, out of court. And his argument was basically the executive power, presidential power. It was the political question doctrine. That's what he relied upon. And the case was done. And I remember Bob Owen, the legal advisor from Covington, coming into my office and congratulating me and saying, Art, this was a big one. I said, I know. He said, I'll tell you what we're going to do. We're going to write a letter to Senator Goldwater telling him he's been the victim of some very poor legal advice, and he ought to fire the guy immediately. Well, of course, we didn't do that, but we had a big laugh, and then we went off to the L, the legal advisor's office is called L, and had a good time. The a crucial case when I was the head of the treaties office was the Dames and Moore case, because the Algiers Accords were not done as a treaty, they were done as an executive agreement. And Dames and Moore, which felt it had a weak case, said, this has got to be a treaty, it can't be an executive agreement. Well, again, I'm asked for a memorandum. So again, I looked at every treaty termination in the history, every claims agreement in the history of America. And it started with John Adams, a little closer to the writing of the Constitution. And he did a claims agreement, some irony here, with a place called the Kingdom of the Netherlands. And he waived claims and he settled claims and he did what he wanted to do with claims and he signed it and he sent it over there. He never sent it to the Senate. That was the first pure claims agreement. And ever since then, we have done claims agreements as executive agreements, sometimes with the authority of statutes before the fact, sometimes after the fact. And when we came later into the 20th century, no authorization at all, more pure executive agreements. And so it was done. And case was argued. I remember coming back, I was already at the Hague, and a few of us went over to the Supreme Court to hear the arguments, the Solicitor General on one side, Dames and Moore on the other. And we placed our bets on how it was going to come out. There were the optimists, the pessimists, and the mugwumps. And the optimists said, we're going to win this 9-0. And the pessimists said, no, we're going to win it 7-2. And the mugwumps, I was a mugwump, said, no, we're going to win it 8-1. Turned out to be 9-0. It was unanimous. I had also thrown in IEPA, the International Economic Emergency Powers Act, which gives the president more power in times of an emergency. Well, we had the hostages, so that was a problem.
Just stepping back slightly, because this was the beginning of the Reagan administration, is when
Yes.
Jimmy Carter's administration negotiated this. And if you were watching President Reagan being inaugurated, you get a split screen with the hostages
Yes.
arriving in,
Yes.
in Germany.
Right.
But I seem to remember there was an issue at the beginning of the Reagan administration. Are we going to stick with this deal, or are we going to scrap it?
Right. I was given that question, can't we get out of the Algiers Accords that we have agreed to? What was the theory of that? The theory was we had a gun at our head. Why? The hostages. And if you have signed a contract or an agreement with a gun at your head, it's void or at least voidable at your choice. And so that was the theory. And I didn't have to look at a whole lot of history for this one. My memorandum said, yes, it's voidable. We can get out of it if we wish. But do we really wish? Iran will have defenses in our courts that they won't have at this tribunal. Sovereign immunity, act of state. They won't have those defenses over in The Hague. And they will have them here. So, yeah, we can get out of it, but it's not a good idea. And Bryce Claggett, representing Amico, went over to the White House, and he spoke with, I think it was Ed Meese. And he said, no, we stick with the tribunal. We don't have the cases heard here.
Well, another significant reason was, are we on? Another significant reason was that you had about 4,000 American claimants, including the major American oil companies who were part of the international concession in Iran, who were looking for their money, and there was $1 billion deposited in the security account under these accords to pay off claims. That must have been a rather persuasive reason, I would have thought, at the White House and a new administration.
Well, The Hague, I mean, the tribunal, I must say, has been the real highlight of my career in international arbitration and international law. There have been many other things that I've done, positions that I've held.
It's a rare privilege to be present at the creation.
Yes,
of something like that.
present at the creation. And it had a number of successes. It had a number of failures. And I'll just quickly go through each because I know we don't have much time. The successes really began with that $1 billion security account. We had $1 billion that, by the Algiers Accords, were to go into that account to be paid to American, and it was mostly American, winners of awards. Nobody wanted it. I had this vision of a man with a cup with $1 billion inside, and nobody wanted to take it. Why not? Because they didn't want to get mixed up with disputes with Iran. I don't blame them. But the Dutch were willing to take it. Why the Dutch? Well, they viewed themselves already as a center of international law. They're more so today. They had the World Court, of course, and they had the Permanent Court of Arbitration. Now they were going to get the Iran-U.S. Claims Tribunal. And my first trip over there, and it was with Mark Feldman, the deputy legal advisor who had asked me to become the agent, we went to the Treasury. And yes, they agreed to take the $1 billion. They tied it up in knots. You needed a Queen's writ to get anywhere near that fund unless it followed the prescribed prescription, which was a payout fund, which really worked. When the president of the tribunal announced there was an award, he announced it to the Algerian Central Bank. They, in turn, instructed the Dutch Central Bank to pay out the funds to the New York Federal Reserve, which contacted the winner, and they made arrangements, usually a wire transfer into a bank account. And the system worked. For the first 2 years that I was there, the first 2 years of the tribunal's life, the system worked, and that was a great success. Another success was setting up the full tribunal, because there were just the 3 Iranians and the 3 Americans. The 3 Americans, Holtzman had a lot of arbitration experience, but it was labor, domestic arbitration in New York. George Aldrich was viewed as somebody whose temperament might lead to compromises. And Richard Mosk, Dick Mosk, was a litigator, a tough guy from Los Angeles. So those were the 3 Americans. But now we had to pick the 3 neutrals, the 3 chairmen. And we spent some time doing that, a lot of names bandied about. We picked Gunnar Lagergren from Sweden. The Iranians agreed. Niels Mangard, also from Sweden. The Iranians agreed. And Pierre Bellet, the Iranians agreed. Now we had a full tribunal. That was a success as well. There were other, just going quickly without spending time on any of them. We had, I think, a success in terms of pre-hearing conferences. I won't go into detail. This was all the credit of Howard Holtzman. I think he did it with labor arbitration. It led to the now famous procedural order #1 and to the UNCITRAL notes. And I think that was a success. The hearings themselves, very short, like 1 day, 2 days. There were witness statements that were allowed in, but you could see the civil law and the common law coming together. They were civil, they were polite, they were not slugging matches, and that was a good thing. And another success, over 300 disputes were resolved during my first 2 years, and the great majority of them were by settlements. Settlements were encouraged by the tribunal. I think that was a great success. Another was, and people will dispute whether this was good or bad, the publication of awards. The registrar had a rule that for $5 you could pick up your award. Well, that's it. That made them public. You could give it to anybody you wanted to. You could copy them, toss them around. They were public. So in our little administrative committee, I proposed that we simply publish the awards in hard volume copies. To my surprise, the Iranians agreed. Now, of course, they're a hard copy and they're online as well. Was that a good thing? I think so. They were in full. They had the names of the arbitrators, the facts of the case, the names of the parties, the dissents. They had everything. It was only in English. And the Iranians did say, has to be in Farsi as well. Well, there was never going to be a publisher of these books in Farsi as well. So I spoke to Eli Lauterbach, who happened to be there, publisher of Grotius publications. He loved to publish things. And I said, Eli, I know they want the Farsi. I know you're not going to do that. But these awards are already public through that $5 approach. So just publish them. And he said to me, are you sure? I said, Eli, just do it. Just do it. And he just did it. And so now we have hard copy volumes of all the awards.
38 to date.
38. And where there was truly confidential information, that was deleted, but there wasn't much of that. So I think it made a contribution. In terms of further transparency, which is a question, Others were allowed in if both sides agreed, but they couldn't do more than sit and watch in the hearings. So that never became an issue.
You mentioned the word slugfest, I think, before, that everything went fine in the hearings, but you must have had a couple of slugfests or near slugfest with your counterpart, Mohammed Eshrag, the agent for the Islamic Republic of Iran.
Yeah. One of the first signs of failures to come was one day when the Mujahideen were throwing around hand grenades and killing people. They killed a man named Beheshti, who was the Speaker of the Majlis, the Speaker of the Parliament. And I knew something was going to come from that. And the next day, Mr. Eshrag, everything was last names, no first names. Mr. Eshrag came into the Peace Palace. We were just about to get our own headquarters on the Parkweg. And he said to me, "Mr. Rovine, I have to talk to you." So we went into a room underneath the staircase that leads up to the ballroom of the Peace Palace. It's a great room for arbitrations. And he said to me, "Mr. Rovine, my government says that this tribunal should move to New Delhi, India." I said, "New Delhi, India, Mr. Eshrag, why?" He said, "My government says so." Oh. I said, "Well, look, Mr. Eshrag, there's no reason to move to New Delhi. We're just about to get our own headquarters. The research facilities here are very good. And many people have already moved into their apartments here. There's simply no reason to move to New Delhi." And he looked at me and he said, "So you reject New Delhi, India?" I said, "Well, for the reasons I've just stated, there's no reason to move there." He looked at me again, straight on, and said, "So you reject New Delhi, India?" And now I knew what he was thinking. That's right, Mr. Eshrag, I reject New Delhi, India. I can't tell you really how he reacted. I don't want to say anything about him that might get him into trouble. He's still living in The Hague, and so I won't. He has said other things as well that I'm not going to repeat because I can't. I don't want to get him into trouble. But it was a sign of Iran's discomfort. They wanted to be elsewhere. This was too Western a place for their taste, and thus that suggestion. It was not a good sign of things to come.
I would just say for background, Mohammed Eshrag had been in New York City and got an LLM from NYU, and I think we can assume he was not displeased personally that this suggestion of his government was rejected by the man with the full power in his hand from the United States to
Yes.
say yea or nay.
I think that's correct. In any event, there were other more serious signs of failure because the Iranians began to attack the neutrals.
Excuse me, just correction, since I'm still a sitting judge of the United States Claims Tribunal. They are third country people are frequently spoken of as neutrals, but actually all of the judges, all 9, are pledged to be independent
Right.
and impartial. You can
And that's a good correction.
make your own judgment as to
Yeah.
who is and who is not. in
Well,
fact, but-
from the Iranian point of view, they were never unhappy with the American people at the tribunal. And they thought they were just doing what they were expected to do, vote mostly with the Americans, not all the time. And nor did they give the Americans all the money they wanted, but for the most part, they were with the Americans. The Iranians, in the name of God, as they put it, were with the Iranians. And they never had trouble with me. I saw indications that they really liked me. And I was just doing my job. I got a later indication. They thought I was doing it very well, but I'll come to that. So the first real problem was with Pierre Ballet. He was the head of Chamber 2, along with George Aldrich. And they had an issue. They were about to issue an award. And as I learned, it had the dreaded phrase, prompt, adequate, and effective compensation for expropriated property, dreaded to the Iranians. And the Iranians didn't show up for the issuance of the award, and set another date, and they didn't show up, and another date, and they didn't show up. And so finally, Judge Ballet and George Aldrich issued the award themselves, the two of the three of them. It had been an issue, but they did what they did. And the Iranians were outraged. They had a temporary agent at that time named Kashan, and he said to Judge Ballet, "You have used irregular measures against us, and now we are going to use irregular measures against you." Judge Ballet called me to his office, and he said, "Mr. Rovine, they have threatened me with violence." I said, I think the words are perhaps ambiguous. He said, "They're not ambiguous." He got upset with me for saying that. He said, "They're clear. They're threatening me with violence." He said, "You know, when I first came here, I was very sympathetic to what the Iranian regime was doing, very sympathetic. But now, I can't take them anymore. I'm biased against them." He used a stronger word than that, which I won't repeat. And he said, "I have to resign. They have threatened violence against me." And he wrote a letter in French to the president, who was Lagergren, and he said, "I'm resigning. I've been threatened with violence, violence." And he left at the same time I did, after those first 2 years of the tribunal's life.
We just might point out that Pierre Ballet had been the Président de la Cour de Cassation in France, the highest, the Supreme Court of France. It was an extremely distinguished gentleman.
When I went to his office, he made that point. He said, "You know, Mr. Rovine, I've been the head of the Cour de Cassation. I don't need this. I really don't need this." And he didn't. Who could blame him? The president, Lagergren, set up a farewell lunch for both of us at the Promenade Hotel, where he had lunch. And it was a very nice lunch. The question was, would the Iranians actually show up? Because it would be more in honor of Judge Ballet. And for the main meal, they didn't show up, and nobody was surprised. We didn't expect them to come at all. But at dessert time, they did come. Mr. Eshrag was now back as agent, and the Iranian team marches in and said, and I quote exactly, "We are here to say goodbye to Mr. Rovine." Judge Ballet was sitting right next to me on my left. I could feel him tense up. They were attempting to humiliate him publicly, and they did. And I gave him a kind of pat on the back, a show of support, but he was humiliated. they had succeeded. And that was the first of the attacks on the chairs. Second, of course,
This sort of thing was obviously carried out, and after you left, and I came to the tribunal, I was witness to Judge Mangard being physically assaulted by two Iranian judges, which is another story. But
yeah,
I think we might...
that was unfortunate. I was there, not for the shoving out of the tribunal, that happened after I left, but I was there for the challenges. He had made a statement referring to the execution of judges in Iran. He denied saying that. He said that, no, I was referring to the execution of judgments in Iran. Okay, well, he was, of course, challenged. And the Iranians didn't challenge him under the UNCITRAL rules. They challenged him as a kind of unilateral, he's not neutral, we judge him not to be neutral, unbiased, he has to go. The tribunal made a ruling that no, it has to be under the UNCITRAL rules. And Judge Mangard did not resign. He kept his post. And so that brought in the appointing authority, a man named Charles Mons, who was appointed by Jacob Varkamp, the Secretary General of the Permanent Court of Arbitration in The Hague. And he had been a distinguished justice in...
At the time, he was still the president of the Supreme Court
That's right.
Of the Netherlands.
That's right. So he came in, he had to make a ruling, and he said this is not a true challenge, not following the UNCITRAL rules, can't be done this way unilaterally, just saying he's not neutral. He dismissed the whole thing. Then they accused him of bias. He had a meeting, a gathering at his home, and I went to that gathering. I had heard rumors that he was thinking of resigning, and that upset me, and I asked him about it. I didn't get a clear answer. That upset me some more, but his wife was there. So I took it upon myself to ask his wife and about these rumors of his resigning, and she said, "Are you kidding? Are you kidding?" She said, "He loves this job. He's never going to resign." He did. Some 17 years later, he resigned, but that's way off.
She didn't say, "I won't let him resign"?
Yeah, no, she didn't say that.
I have to tell you, as you may recall, his wife was from Friesland, which is a province of the Netherlands. They're a little bit different. They actually have their own language, and they're tough.
Yes. So that was a failure, obviously, and it was bad. And Lagergren, the president of the tribunal, also, this was later, had reason to fear violence against him. And he resigned as of October 1, 1984. So all of the chairs originally named were gone. And that was a failure. There's one more interesting story that I'll let you judge whether it was a success or a failure. I had my last lunch with my counterpart, Eschrag. We ate at the Lange right near the US Embassy, as it was then located. And he said to me, "Mr. Rovine, we understand that you're going to New York." That's right. "We understand that you're joining a law firm there." That's right. "Well," he said, "Mr. Rovine, my government has a very important proposition for you." "What's that?" "We want you to represent the government of Iran at this tribunal." I said, "Mr. Eschrag, I'm truly flattered, but you must know I can't do it." The answer is no. The firm has many cases against Iran. I'll probably be arguing some of them. Even if I weren't arguing any of them, the firm has many cases against Iran. The answer is no. He said, don't you say no. Take it back to your partners. Let them make a judgment on this. I said, for the sake of completeness of the record, I will do that, but I can tell you right now, the answer is no. And that was the end of that conversation. I did take it back to the firm, and of course the answer was no, a little laughter, and the answer was no.
Well, you spent a number of years as a partner at Baker McKenzie, and with great distinction, and been sitting also as arbitrator. But I should ask you, in all the years you acted as counsel, were there one or two particularly memorable cases that you were involved in?
Well, the most memorable were the two cases I lost. Those are the cases you really remember. The cases you win, you win the case, you put it behind you, go on to the next case. But if you lose, you remember it. And yeah, I lost two cases, and I wasn't happy about it. I was there for 22 years, and losing only two was maybe a very good record, but I remember those two. There were a couple of other memorable cases, but nothing like losing a case. That's memorable.
Okay. So while you were doing all of this, you were extremely involved in other public service. You were on the board of editors, of the American Journal of International Law. You were chaired the section of international law of the American Bar Association. You chaired the International Law Committee of the New York City Bar. And of course, crowning all of this was being president of the American Society of International Law. And I understand one day you were surprised to open an envelope, and it was a letter addressed to you from Justice Sandra Day O'Connor. What was that about?
Well, that was the most important of my service as president of the society. She said that, in her view, and she became very much interested in international law right after the Supreme Court vote, which made Bush president, Bush against Gore. Why she became interested in international law at that point, I don't know, but she did. I was president of the society from 2000 to 2002, and it was right then that I got this letter. And her point was that international law was not being argued frequently enough or well enough in the US courts. And she wanted a meeting. And we had that meeting. She called a judge to be sent to this meeting from each of the 11 courts of appeal, circuit courts of appeal around the United States. And each of the courts, obviously, given her command from the Supreme Court, came. So we had a meeting, and we sat around the table. She was on my left. She made her point, and then we went around the table to each of these judges from circuit courts in the United States, and of course they all agreed with that point. And then came her question, can the society do anything about this? Mm-hmm. I said, yes, we can do something about it. We can produce a book on international law for use by the clerks, and they can help their judges, both district court and appellate court, Supreme Court level. We can produce a book, and we did. And how helpful it has been, I don't know. But that's what we did, and she seemed happy with that.
Yeah. And I just may add, the society is continuing on this course, and she has been replaced by the rock star RBG, chairing the
Yes.
matter for the American Society of International Law.
I should say one more thing about Sandra Day O'Connor. I invited her to give the keynote address at the annual meeting of the Society, and she came to give the keynote address on international law and U.S. courts. And when I introduced her, I told the audience that she was born in a place we call the Gadsden Purchase. The Gadsden territory from Mexico, really purchased for a very small amount of money by Mr. Gadsden to allow railroads to go through to California. She was born in that territory.
This was in Arizona.
Yes.
Right.
And so I said that Justice Sandra Day was born in an instrument of international law, an international instrument. She had never thought of it that way, and she was very happy to think of it that way. And then she gave her speech, for which she got a standing ovation. Here was a very liberal crowd, the American Society, giving a standing ovation to a very conservative justice of the Supreme Court because of her talk on international law and U.S. courts, no doubt prepared by clerks, but she gave it and she gave it and gave it well.
Right. Well, Arthur, I know you spent some years following Baker McKenzie, doing great things at Fordham. We're approaching the magic hour, and I think it might we might wind up with what is the future of international arbitration, particularly for those who are at the beginning of their careers and might be wondering more than some of us as to what the future may hold. You've got on the one hand, you've got a lot of, as you call it, convergence. The rules of the various administrative bodies seem to resemble each other more and more, and one gets a good idea, and then others pick it up, and you've got the UNCITRAL model law and so forth. On the other hand, you've got the European Union trying to destroy international arbitration, at least for the member states of the European Union, and if they can convince other states to opt into whatever they may eventually put together, hopefully not, but they may at the end of the work, a working group 3 of the United Nations Commission on International Trade Law. You've got these sort of competing forces. What can we look for next year, the year after, down the road?
I think we're in a period of convergence in the way we carry out hearings. For example, preparation of witnesses. Civil law countries, that's a real no-no. You can't do that. Common law countries, you might be guilty of malpractice if you don't do that. How do you deal with that? Well, a compromise was reached. The civil law folks saw that the common law witnesses were generally better prepared than theirs. So what they did was to start to prepare them for international arbitrations. For domestic arbitrations, preparation remained a no-no. Okay, it was a degree of convergence. Cross-examination, another example. I was raised to just kill the guy, just wipe him out. And I learned quickly that civil law lawyers don't like that. Polite cross-examination can be done, is done, and you can ask very difficult questions, but still be polite about it. And I learned that, and it was interesting. I once cross-examined somebody in an Iranian case, and he was put up as an expert on valuation of assets that had been taken. And I said, leading question style, after he was examined as an expert, I was cross-examining. I said, "You're not a partner in your firm, are you?" Tremendous reaction on his part. He blushed, he squirmed. I had really upset him.
This was a mature individual.
Yes, absolutely. And I then, on the spur of the moment, decided, given that reaction, which I viewed as extreme, I would ask him the second question, which I really took a risk in asking. I asked him, "Why not? Why are you not a partner?" The Iranians went crazy. "Stop the hearing, stop the hearing. Mr. Rovine's just trying to embarrass the witness." It was a mean question, but it worked. I mean, he was through for the rest of the hearing. He was ineffective totally. Would I ask that same question again today if I had it to do over again? People differ on that. Some people say, yeah, I would. Others say, no, I wouldn't ask that question. It's a question. I had another issue. I did have a slugfest of an arbitration in Paris to last 2 weeks. And we had a very important American contract law issue. And I called up Alan Farnsworth, Columbia Law School, and asked him to be an expert for us. He said, "Arthur, I'm sorry, the other side beat you to it. I'm an expert for them." I thought, oh God, I have to cross-examine Alan Farnsworth, who knows everything about American contract law. Most people don't even try. They just take what he says and try to work their way around it. And but I took my team to Paris. We had a schedule of witnesses. He was scheduled on the second week. And I show up first thing Monday morning, 9 o'clock, and there's Alan Farnsworth sitting there. So I said, "Mr. Chairman, I object. Professor Farnsworth is scheduled to testify next week, not this week." And the chairman, to my surprise, said, "Mr. Rovine, what do you want me to do? He's sitting right here, ready to testify." And I said, "Mr. Chairman, just send him home. Just send him home." And the chairman looked taken aback, but he looked at his two wingmen, and they nodded yes, and he said, "Professor, you're excused." And the case settled after 1 week. And so he never did have to testify. And I got home, and I called him up. I said, "Alan, I was sorry to have done that to you." He said, "Sorry? What do you mean sorry? That was sensational. I come to Paris, I do my usual sightseeing and shopping. I come into the hearing, I'm all set to testify. You say send them home, they send me home. I go back into the streets of Paris, more shopping, more sightseeing. And then I go home, and it was all expenses paid. What could be better than that?" And he said, "Besides, Arthur, it was a tribute, wasn't it? You didn't want me to testify, did you?" I said, "No, Alan, I didn't. And I certainly didn't want to have to try to cross-examine you." So, question, would I use those words again? Were they harsh? Just send him home, Mr. Chairman, just send him home. Again, some people say, that's fine. Other people say, a little harsh.
Well, we could go on forever. It would be a great joy, but we have to send ourselves home to the next session. I think it's been really just wonderful having this chat with you.
Thank you.
Okay.